The news headline: Council urges court to reinstate bill previously granted Kanu. You're welcome to the news. Please listen to the end. The news details. The Federal High Court, Abuja, has been urged to reinstate the bill it hitherto granted the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, who has been standing trial before it for alleged treason. Special counsel to Kanu and IPOB, Mr. Ejimako, while reacting to a news report titled "Why Kanu's Bill Should Be Vacated," urged the court to reinstate the bill. He said that it is Kanu's arrest warrant that should be vacated and not his bail. Ejimako said that the judgment of the Abia State High Court, delivered on June 19, 2022, by Justice Benson Anya on the fundamental rights suit filed by Kanu, paved way for his previous bail to be reinstated. Of particular note is whether the judgment should directly or indirectly impact the persisting notion that Kanu jumped bail in 2017, which was what granted the bench warrant that was used to justify his rendition. He argued. He added that the bench warrant upon which his Kanu rendition from Kenya was granted has now become impeachable and liable to be vacated. The counsel to Nnamdi Kanu urges the courts to reinstate the bill that was previously granted Kanu instead of the arrest warrant. That it is the arrest warrant that should be vacated and not the bill. So the court should reinstate the bill that was previously granted to Nnamdi Kanu. Nnamdi Kanu is the leader of the indigenous people of Biafra and has been in the custody of the DSS for a while now. Nnamdi Kanu, who jumped bail in 2017, which was what granted the bench warrant that was used to justify his rendition. And this is coming when it says why Kanu's bill should be vacated. Special counsel to leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has stated that the bench warrant upon which his rendition from Kenya was granted has become impeachable and liable to vacation. In a statement issued, Ejimako stated that his submission was necessitated by the outbreak of public commentators on the Abia State High Court judgment of January 19, 2022, on the fundamental rights suit he filed on which the court ruled in Kanu's favor. He submitted that the ruling of Justice Benson Anya of the Abia State High Court also paved the way for his previous bill to be reinstated. Ejimako stated that most of the public comments bordered on examining the latent impact that the judgment might have beyond the 1 billion naira awarded to Kanu against the federal courts and the order for the government to apologize for Kanu for infringing on his fundamental rights by the military invasion of his Afara Uku home in Umuahia North Council in Abia State in 2017. Of particular interest is whether the judgment should directly or indirectly impact the persisting notion that Kanu had jumped bail in 2017, which was what granted the bench warrant that was used to justify its detention. In summary, the verdict has created new legal opportunities for Kanu, especially as regards impeaching the bench warrant, his incarceration. From late 2017, I had maintained that Kanu never jumped bail and that he will, in due course, prove that it was the federal government that compelled him to flee the country. This was the material issue before the Abia court, and it prevailed, he said. He added that it is the view of the court that the army set out to kill Kanu, insisting that the military invasion of his Afaraoku Ibeku country home was such that the court could not ignore it, and that Kanu deserves an apology and compensation. The court held that Kanu has, by credible evidence, proved to the court that the federal government threatened his fundamental rights to dignity of the human person and personal liberty. In other words, the court held that Kanu never made a voluntary decision to flee the country or to be absent from his trial. To this extent, the judgment has obliterated the vested and false notion that Kanu jumped bail in 2017. He added. The counsel to Nnamdi Kanu has said that the bail of Nnamdi Kanu that was passed across should not be vacated, but his arrest warrant. Nnamdi Kanu, who was extradited from Kenya to Nigeria, he was on his way to Kenya. He was on his way to British. He was already at the Kenya airport, and he was arrested in that airport. The council is now saying that what he knows the international airport for is to safeguard the lives of people, but the Kenya government has made sure that their own airport has been known as abduction ground. But the IPOB council, Ejimako, is saying that the Kanu's bill should be vacated, and also he urges the court to reinstate bail that was previously granted Kanu. Thank you.